In this video, I'll be beginning with the pairwise discussion of the moot court proposition of the Delhi University's moot court competition justified. Now, before I begin with the pairwise discussion, let me first discuss the basic layout as to how will I be teaching you this moot court proposition, or rather discussing it. So, I have laid out all the important points. In fact, 90% of the facts of the moot court proposition are laid out herein, and I'll go and discuss with you each and every line, each and every paragraph in as little time as possible, right? I'll try to keep it as concise as possible so that you get information, a lot of information in as little time as possible. So as you can see, by way of example, in this paragraph there are certain lines which are highlighted in yellow, certain in blue, and certain in red. So that is the color scheme that I have chosen for my discussion. The yellow one means that it is a neutral fat. So for example, these two are so and so countries, so this fat is not going in favor of any person, so therefore it is a neutral fat and therefore it is highlighted as yellow. If certain fats are going in favor of the applicant, and by applicant I mean the Republic of Seplica, so that will be highlighted as blue, because generally in motor competitions the applicant has a memorial of blue and the respondent of red. And whenever you see red highlighted lines, so that means that is a fact that the respondent can use in his or her favor. So let's begin. So I'll start by discussing three relevant laws or rather clauses that is given in the moot court proposition. That is, first is Article 40 Clause A of the Court Statute. Now court here means the International Court of Justice, that is ICJ. The second is Article 2 of the agreement, that is the agreement signed by Seplica and Kartha to go to the ICJ. And the third is Article 38 Clause 1 of the Court Statute. So let me discuss this one by one as quickly as possible. So 40 Clause 1 of the ICJ statute says that the cases are brought before the court as the case may be, either by a notification or special agreement or by written application addressed to the registrar. In either case, subject to the dispute and parties shall be indicated. So that is a very general thing, but what does it signify? So that is the jurisdiction clause of the ICJ. So whenever you are writing down in memorials as to what is the jurisdiction, so therefore this is irrelevant. And if the judge asks you that how have you come before us, so you simply answer, your lordship, we have come before your lord, my lords, under Article 40 Clause 1 of the court statute. Now when I say your lords, I actually mean your excellency or your honor or whatever designation that is going on as per your moot court rules, so you please look into that. The next thing is Article 2 of the agreement, that says that it is agreed by all parties that Republic of Seplica shall appear as an applicant and Karth as respondent, and so forth. Now, one important thing to be noted here is that although it is stated in the agreement that but such agreement is without prejudice to any questions of the burden on proof. Now it is a very important line because it is written especially because normally what happens is if somebody is an applicant or a petitioner, then the burden of proof, as you may know, is originally on the plaintiff or the applicant, and he has to prove that whatever he or she intends to prove, and only when the burden of proof is shifted, then the respondent's liability increases. Right, so that is a general law. But herein, since both the parties had grievances, so who will become the applicant and who will become the respondent, because at least one party has to be an applicant and one has to be respondent. So therefore, this party decide, okay, for the purpose of this case, I will appear as an applicant and you will appear as a respondent, but however that will have no prejudice as to the burden of proof, right? However, I'll tell you one small thing that you can try, at least try before the judges, is that you can say, that is what the respondent, that is the Kartha, can use in its favor is that he can say that I am the respondent. and therefore the burden of proof is not upon me. Even though it is specifically mentioned that without prejudice to any question on burden of proof, still an argument can be made, which you can see in this comment box, is that agreements do not override law. If the law says that the burden of proof is on the applicant or the plaintiff, then by a specific agreement you cannot override that law. For example, if there are two parties who are contracting in Bombay, and then in the contract that mentioned that the jurisdiction will be of Delhi court, that is not acceptable. You by an agreement cannot change the law, and the jurisdiction will be of Bombay court only and not the Delhi court. Similarly, you can also argue, I mean the respondent here can argue, but even though it is written specifically that there are no prejudice as to the question of burden of proof, still I cannot override the law. Therefore, the onus of proof should be on the applicant and not on the respondent. So you can try this, right? I have mentioned all of this, and I have given you a link also which you can read for your further understanding. What can be the counter argument of this argument? For example, if somebody makes, or if a judge asks you. So a simple counter is that you can also draw a parallel from what the Indian courts follow. So I'll just give you an example of framing of issues in Indian courts. So even if there are applicant and respondent, still what happens is that whenever issues are framed in any civil matter, let's say in India, so above each issue, either it is written OPP or OPD. What OPP means is that the onus of proof is on plaintiff. OPD means that the onus of proof is on defendant. So if somebody is saying that, okay, since I am the applicant, or therefore I am the respondent, therefore burden of proof is not on me. So you can counter that by saying that, okay, but here it is not mentioned where is OPP and where is OPD, because even in Indian courts you have to specifically mention against each issue that upon whom the burden of proof lies. The burden of proof does not lie as per respondent, defendant or the applicant. It depends on what is marked as OPP and OPD in the issues at the time of issues framing. So you can give this counter argument. The next is Article 38 of the court statute, which basically discusses various sources of international law, and that is a very important clause that you will have to refer while arguing every couple of minutes, because you will be taking the examples of judgments of this court or another court, contemporary or corollary court, or any journal or any article written by a legal luminary. So therefore the judges will say what is the evidentiary value of whatever this person said, or this jury said, or this court said, or whatever it is said, because obviously you will not find each and everything in support of your argument via an ICJ judgment only. You can find anything, an article also, or any national court judgment, or anything else, or any agreement, or any precedence in UN that you can use in your favor, or any book written. So therefore when the judge asks you what is the evidentiary value, always say that I am drawing my evidentiary value from Article 38 of the ICJ statute, which are mentioning the various sources of international law which are acceptable to the ICJ, right? So in the A clause you will see international conventions, B says there are customary law, the C says there are general principles of law, and the D says judicial decisions and teaching of the highly qualified publicist. So whenever the judge is saying what is the evidentiary value, always quote Article 38 clause 1 and the relevant subclause A, B, C, D respectively. So that's all guys for this video. In this video I'll begin further discussions and well into the further paragraphs.